Hi everyone, let's talk about franchises and other business forms. In this lesson, we'll define franchise and describe the various forms. We'll describe a franchise agreement and its terms. We'll identify the liability of franchisors and franchisees. We'll define licensing and describe how trademarks and intellectual property are licensed. We'll define and describe a joint venture, and we'll define and describe a strategic alliance. So this wraps up our series on the different types of business formation, just analyzing pros and cons, ins and outs of different business forms like sole proprietorships, partnerships, corporations, S-corps, LLCs, and then we'll wrap up with franchises, licensing, and strategic alliances. So you should have at least a general idea of some of the pros and cons and what these different business forms have to offer. So we see franchises all over the place. The most common ones we see are fast food restaurants that we see as we're just driving around anywhere. Those big names are all franchises. Well, most of them are franchises. Some have a slightly different model. But they're very common out there in society. So why do people franchise? Well, it allows you to open up a business, but you don't have to build a reputation and product and a process all on your own. You basically are just using somebody else's trademarks, their logos, their branding, their business model, their products, their services. So it's sort of a turnkey business solution. And what you have to do is provide the money to open it. You have to provide ongoing fees to the franchisor. And then you have to run the day-to-day operations. So some people might think it's an easier way to start with an established business brand. But getting into some definitions. So a franchise, okay. So there's an arrangement where one party licenses another party to use their trade name, trademarks, commercial symbols, patents, copyrights, and other property in the distribution and selling of goods and services. The franchisor is the one who grants the franchise and license to a franchisee. The franchisee is the person who is granted the franchise and licensed by the franchisor. So we use that terminology as we go on through the lesson here. Visual may be helpful, maybe not, but the franchisor, also sometimes called a licensor, grants the use of a franchise and license to use trademarks, service marks, and trade secrets to the franchisee. So if I want to open up a McDonald's franchise, I have to get permission from McDonald's corporate in order to open that franchise. Then I am able to use the McDonald's Golden Arches logo. I'm able to use their trademarks, names like Big Mac and all that, sell McDonald's products, all under the umbrella and the name and the reputation of McDonald's while being an independent franchisee myself. Okay, so we'll look at a few types of franchises. So it's easy to think of fast food restaurants, but there are lots of other different types of franchises out there. Those I'll use those as illustrations and examples a lot just because they're the most common ones that we see around. But there's a lot of other kinds. So one kind of distributorship franchise. This is where a franchisor manufactures a product and then licenses a franchisee to distribute the product to the public. So an example of this would be car dealerships. The way that cars are sold in the United States is kind of weird. We all basically have to go through dealerships, although Tesla is sort of trying to change this model. Maybe it'll change, maybe or not. But right now, what we're stuck with is the dealership model. So Ford or Toyota or Honda or whatever other car manufacturer actually makes the cars, but they don't sell them directly to the public. They sell them through dealerships. So they grant the licenses for franchisees to use the name Ford or Toyota or Honda or whatever, and then sell those manufactured cars to the public. Maybe one day we'll see direct sales from a manufacturer to the public of automobiles in the United States. I don't know. Some people question whether or not we actually have to use dealerships, but as it stands now, we go through dealerships. Okay, then there's a processing plant franchise. So now here's where a franchisor provides a secret formula or process to the franchisee, who then manufactures the product and distributes it to retail dealers. Sounds complicated. It's really not that bad. A good example would be Coca-Cola. Doesn't actually manufacture the end product that we buy in stores. What they really do is just manufacture syrup concentrate. Then they distribute that concentrate out to independently owned bottling companies who have been granted the license to produce. So they'll add the remaining ingredients, whether it be the water and the CO2 or whatever else goes into it. And then they'll distribute and sell those soft drinks to the public, all under the name Coca-Cola, and then Pepsi does the same thing. And then some of the other soft drink manufacturers can do the same thing, although some might sell directly to the public as well. Chain style franchise is the one that we're most familiar with. It's where a franchisor licenses a franchisee to make and sell its products to the public from a retail outlet serving an exclusive territory. So the example being most fast food restaurants. I'll give you a little mini lecture here, or a mini sermon, or a mini rant, I guess, on what are called multi-level marketing companies. These are the companies that sell things like health shakes, health products, essential oils, certain types of clothing, whatever. They go under a bunch of different names, but this is when you see your friends start trying to sell a bunch of stuff on Facebook or whatever social media you're using. And these aren't really franchises. An advantage that franchising actually gets you is you usually get some type of exclusive territory. That's pretty important, because you don't want to have 150 McDonald's in Gastonia. That would be too many, and you'd start cannibalizing sales of other McDonald's locations. You want to have some exclusive territory. You can't have another McDonald's within a certain mile radius, or looking at the population of people and how many can support. And those MLMs don't do that. They just try to maximize the number of people who are buying and then trying to resell their products. So getting involved in an MLM is generally a bad idea. Most people lose money, or at least don't make any money at all after putting in a lot of work on those. So if you can avoid them, fantastic. If you happen to be one of the people that gets in early and makes a ton of money, great. You've proven me wrong. Go and be well in your life. So that's a chain style franchise with an additional mini rant on MLMs. The last one we'll talk about is the area franchise. This is more common when a franchisor is trying to enter a market, maybe in a different country, or they're not used to doing business and don't know the culture and the people all that well. So we go through somebody else. It can be risky moving into international markets, so businesses try to find ways to hedge their bets and limit their liability and try to increase their probability for success. So here a franchisor authorizes a franchisee to negotiate and sell franchises on its behalf. So we're sort of adding a middleman into the deal. The area franchisee would be called the sub-franchisor. Like I said, when you're trying to move into international markets, oftentimes this kind of arrangement is used, although not exclusively. An example could be McDonald's Corp. Granting a master franchise to Arcos Dorados Holdings Incorporated to operate McDonald's franchises in 20 countries of Latin America and the Caribbean. Small visual here to illustrate. You have the original franchisor. They're granting an area franchise to a sub-franchisor who gets some exclusive territory in which they're going to operate. And they're going to open up franchises, franchising out to the franchisees in that territory. And then hopefully it works out for everybody. There are a lot of regulations surrounding franchises because it was easy for people to scam other people into investing a lot of money into franchises that were worthless and losing a lot of money and just taking advantage of people. So the FTC steps in and creates a bunch of regulations, and your state might also have regulations itself. So I'll give you a link there to the FTC website so you can read more. The FTC does way more than just regulating franchises, but that's the context that we're talking about today. So the franchise rule of the FTC requires franchisors to make full pre-sale disclosures to prospective franchisees. So what this does is allow a prospective franchisee, if I'm thinking about opening up a Subway or whatever, I can go through and look at a lot of disclosures to gather a lot of information before I actually commit the time and the money into trying to open up this franchise. So hopefully that increases my likelihood of success and helps me steer clear of things that I don't think will be successful in the long run. There are a lot of things that have to be disclosed, 23 items listed in the FTC's guidance. But they include things like obviously a description of what the business actually does and sells, the experience of the people owning the franchise, any litigation history or bankruptcy history, whatever the required fees are going to be, an estimate of the total initial investment required to open up the franchise, and then any restrictions on what can be sold, any financial information that they have, etc. So trying to give you as much, trying to make you an informed buyer of a business before you actually commit the money to it. At least that's the goal. Now, we live in a world where success is not guaranteed. Nothing is guaranteed. You're not going to be guaranteed to be successful, but at least it gives you enough information to where you can do your due diligence and hopefully be more successful than going in blind. We'll look at some aspects of some of these disclosure laws, not all of them, just some of them, some examples. So one example the book talks about is when you're making disclosures about sales or earnings projections. And those can be based on either actual data or can be based on hypothetical data. And so you have to disclose whether it's actual or hypothetical and have statements in there just letting people know what's going on. So for using actual data, then you have to disclose the number and percentage of its actual franchises that have obtained such results. So if we have 100 restaurants that are operating under this franchise, we can't just show you the results of the most successful one and then let everybody assume that they'll be as successful as the number one performer. We have to show, how many actual franchises are there out there? How many are obtaining results that are like this, so I can get an idea of how successful can I be? And then you have to have cautionary statements in there, at least 12-point, bold-faced, typed, just trying to keep people from burying these statements, way down in the legalese. But it would say, caution, some outlets have sold or earned this amount. There is no assurance that you'll do as well. If you rely upon our figures, you must accept the risk of not doing so well. So just like I said, nothing's guaranteed, but we're at least making disclosures so you can be an informed potential business owner or franchise owner. When you're basing it on hypothetical data, okay, so now we're making some assumptions and we're projecting out based on what we think you might be able to do, not actual sales that real franchises have actually done. So when I do this, if I do this, I have to disclose what are the assumptions underlying the estimates. How do I arrive at the numbers that I'm giving you? What the number percentage of actual franchises that have actually obtained these projected results. If we already have data about how franchises are performing, how many are actually achieving, how close are they getting to these projected results? And then another cautionary statement in at least 12-point, bold-faced print. Caution, these figures are only estimates of what we think you may earn. There's no assurance you'll do as well. If you rely upon our figures, you must accept the risk of not doing so well. So these are examples of the kind of things that are required in disclosure laws. If you go to the FTC website and you can find rules regarding FTC franchise notice, another one of these required statements that's in there to the effect of, the FTC is requiring them to make these disclosures, but they don't have the resources to really investigate everything. So you're going to have to do some due diligence on your end. Nothing is guaranteed. You might still lose money. That's not necessarily going to be the FTC's fault, or maybe not even the franchisor's fault. But all this to try to make you, again, an informed potential franchisee. And like I said earlier, your state might have disclosure laws as well, and they might require what's called Uniform Franchise Offering Circular. Now, North Carolina doesn't have specific franchising laws, but we do have something called the Business Opportunity Sales Act, which can loop in a bunch of franchises in it and then make them subject to that particular law with all these different disclosure requirements. But North Carolina, this law is weird because there's a large carve out and a large exception saying that if a company has a federally licensed trademark, then they don't have to, under North Carolina law at least. They would still have to comply with the federal regulations. So, that excludes or that accepts most of the big name, what we think of like the fast food restaurants and whatever, all the well-known franchises out there don't have to comply with this particular act in North Carolina. The franchise agreement. This is going to be the guiding document for you between the franchisor and the franchisee, setting out, this is going to be our contract. It sets forth the terms and conditions of a franchise. It's often incredibly detailed and often very strict, often with very little room for negotiation, especially if this is a large and experienced franchisor. Now, if it's a mom and pop who's just trying to get up and off the ground, it might be as detailed or as strict. But for the bigger ones, why is it this detailed and strict? For a pretty good reason. The franchisor, the person who has built this business and owns the intellectual property and is responsible for the branding of it, they want to protect the reputation and the public's perception of their intellectual property. They don't want their brand name, their business name tarnished because one rogue franchisee is out there doing crazy stuff and has completely gone off the rails and is harming the franchisor's reputation. So that's why it's detailed, that's why it's strict, and that's why there's not that much room for negotiation in those agreements. More of a take it or leave it type situation. As far as liability goes, looking at what the liability of the franchisor and the franchisee is, the general idea is that parties are responsible for their own contracts, for their own negligence, for their own torts, whatever. The franchisor and the franchisee, are treated as separate legal entities as long as the franchise has been properly organized and is properly operated on a day-to-day basis. So the franchisor is dealing with the franchisee as an independent contractor, an independent business owner. So, like I said earlier, franchisors, franchisees liable for their own contracts and torts. Neither is liable for the contracts or torts of the other. Now, there can be exceptions to this, but what we're doing is assuming a situation where everything is properly organized and operated, where each party is responsible for their own mishaps or contracts. So a case to illustrate franchise liability, we have Salazar versus McDonald's Corp. This happened in 2019, went to the United States Court of Appeals in the Ninth Circuit. So we have a franchisee, Haynes, who operated 8 McDonald's franchises. McDonald's and Haynes were sued on behalf of a class of employees working under the Haynes umbrella for denied employee benefits. So they didn't think they were getting the benefits and the pay that they thought they should be getting. So they sued not only Haynes, who owned their particular McDonald's franchises, but also McDonald's corporate. So McDonald's corporate is trying to argue that they shouldn't be part of this lawsuit. They're not involved with the day-to-day of how Haynes operates his own franchises, and thus they need to be released or dismissed or taken off this lawsuit, and then it should be Haynes' liability. And that's ultimately what the court decided. They didn't see any reason for McDonald's corporate to be held liable here. It was Haynes, the franchisee, who was liable for wronging these employees. So it should be his liability, not McDonald's corporate. Now you can contrast that with the situation, if anybody remembers the hot coffee lawsuit that McDonald's faced, must have been 20 years ago. But this is a case where a lady bought a cup of coffee at a McDonald's. She tried to open it while she was sitting in a car. It spilled over her legs and she got some horrific burns to the inside of her legs. And so they sued McDonald's. And that was a little bit different because the reason why the coffee was so hot was because McDonald's corporate had that in their operating procedures. That's how all the franchises were supposed to do it. So it was McDonald's corporate making this decision rather than franchisees. So it was easy for the court to assign liability to McDonald's corporate rather than just the franchisee. In that instance, because it wasn't necessarily the franchisee's fault, they were just following guidance from McDonald's on how to operate the restaurant. So it can depend on the circumstances as to who's liable in a given situation. Another example being Espinoza versus Acor North America Incorporated. This went to the Court of Appeals in Louisiana in 2015. But so this was a case where Acor franchised a Motel 6 at a Bayou Hospitality. Franchised a Motel 6 to Bayou Hospitality LLC. Espinoza, who was a guest at the motel, was shot by an armed robber in the motel parking lot. Espinoza sued Acor for negligence, saying it was vicariously liable for negligence of the motel. Basically, there was a hole in the fence. The robber went through the hole in the fence to access the parking lot, and Espinoza is saying, well, it was the negligence of Motel 6 that caused this hole to remain in the fence, which is how the robber accessed the parking lot, which led to Espinoza being shot. Okay, so then we have to figure out whether or not the franchisor is liable for the franchisee's negligence. So the court looking at it didn't see how Motel 6 corporate was liable because Bayou Hospitality had control over day-to-day operations. They were the ones that should have noticed the hole in the fence and who should have fixed the hole in the fence. Motel 6 wasn't involved in the day-to-day operations enough to have noticed that and been able to fix it. So they found that the franchisee was liable, but they were able to remove Motel 6 from that lawsuit. So one thing to be aware of, not that this happens all that much, but it's something that could potentially happen, and it can pop up in places where you don't expect it. But the basic idea is that, so we just talked about liability, and generally the franchisor and the franchisee are liable for their own negligence and not responsible for the other person's liabilities. But that can change if one party is the agent of the other. So if the franchisor names a franchisee and calls them an agent, so then that opens up the possibility that the franchisor would be vicariously liable for the agent's actions, as we've studied in previous chapters. Now, that doesn't often happen. We usually want to have that separation, so it's not that common that a franchisor would actually name a franchisee as being an agent. But there can arise situations in which it looks like, or it appears, or it's apparent that a franchisee is acting as an agent of the franchisor. So that's what this slide is about. It's an agency that arises when the franchisor creates the appearance that a franchisee is its agent, when in fact an actual agency doesn't exist. But the fact that it appears to be that way could be enough for a court to decide the franchisor has liability in that situation. So it's pretty important to be clear, if I'm the franchisor, to be clear that the franchisees are independent owners of businesses, independent proprietors. It's being run by the independent proprietor. They're not agents of the franchisor. And you oftentimes see this. Sometimes you walk in a restaurant, there will be a sign somewhere saying that this restaurant is independently owned and operated by, XYZ Corporation or a person's name or whatever. And that would be notice enough to notify the public that the franchisee is not an agent of the franchisor. So, it starts to sort of make sense why we see the things that we see once we study these aspects of the law, and why are people doing this? In this instance, it's to avoid a potential situation where a franchisor could be liable because of apparent agency. So the case that deals with a parent agency, or at least a possibility of a parent agency, is Kids Are Kids International Incorporated versus Cope, happened in the Court of Appeals of Georgia in 2015. But Kids Are Kids, known as KRK from this point on, is a franchisor of daycare centers and was granted a franchise to Gonzalez Foods Incorporated. A person named Cope sent their 3-year-old son to this KRK franchise and was injured at the daycare. Cope then sued KRK, alleging that Gonzalez was an apparent agent of KRK, saying that they, based on the name, they believed that Gonzalez was an apparent agent of KRK. When analyzing the situation, we find that in the documentation, there is disclosure that this center is a franchise and is independently owned and operated. There was a certificate hanging up on the wall saying that it was a franchise and independently operated. So the court, looking at it, wasn't able to tell, or at least Cope wasn't able to prove, that there was an apparent agency here just because she believed it. They would have had to demonstrate that there were other factors that would lead one to believe. All the factors and all the evidence led to the proper disclosure of it not being an agency relationship and being a franchise relationship there. So was Gonzalez, the franchisee, the apparent agent of KRK? The court decided no, and they released KRK from the lawsuit. Gonzalez could still sue. Cope can still sue Gonzalez Foods Incorporated, but not KRK, the parent company, the franchisor. Okay, so franchises can be terminated, but there are rules regarding, can a franchisor just at their own personal whim decide to terminate a franchisee's business? The answer is pretty much no in most cases. Franchise agreements permit a franchisor to terminate the franchise for cause, but not at their will. That's what these 2 points are saying. So for cause would be, well, the franchise wasn't paying their franchise fees, there were maybe quality control issues, or whatever else. Maybe they just violated the franchise agreement in some way. That would be for cause. A termination at will clause, if it's included in the franchise agreement, is generally going to be found to be void on the grounds that it's unconscionable. It would be unconscionable for somebody to spend the time and the significant amount of money that it costs to open up a franchise, only for the franchisor to, at their whim, for no particular reason, to be able to just terminate that franchise for no reason, causing extreme expense and injury to the franchisee. So I had a personal friend several years ago who worked for Subway. He actually didn't work for Subway. He worked for a large franchisee that owned a number of Subway locations. But anyway, my friend's job was to go around and basically audit the franchise locations to make sure that they were keeping up with quality standards, to make sure they were operating according to the standards set forth by Subway and the franchisor and the franchisee. And basically just go in and evaluate them. And if they weren't doing what they were supposed to be doing, it was entirely possible for the franchisee to lose that location and for it to be sold off to somebody else. So it's possible, but we usually have to find a cause. It can't just be for no reason. So since the franchise agreement is a contract, it's an enforceable contract. When somebody breaches that contract, then the aggrieved party can sue the breaching party for rescission, for restitution, and for damages, whichever combination of those things makes the most sense given the circumstances. If a franchisor terminates the franchise agreement without just cause, the franchisee can sue for wrongful termination of the franchise. They can recover damages as well as recovering ownership of that franchise. Well, we're going to switch gears to licensing real quickly. I wanted to take just a minute to show you. This is a website, NerdWallet, and they, just looking at franchise opportunities. So they have, I'm not saying that these are necessarily correct. I'm just saying that this website has ranked several franchise opportunities and sort of given some basic information. I think this is interesting to look at in case you were thinking about trying to open up or buy a McDonald's location or Subway, Sonic, whatever. To look at the kind of things that you might need to know and might need to have in order to open one. So for McDonald's, these values can vary, but based on their guesstimation here, the initial investment somewhere between $1.2 and $2.2 million to open up a McDonald's location. McDonald's corporate usually requires that you have at least $500,000 liquid. That means accessible without having to sell real estate or some other, burdensome property there. Prefer to be cash or, investment account or something like that that's easily turned into cash. So you have to have a significant amount of money because they want to be sure that you have the capital required to actually get this thing up off the ground and running. Once you're running, you have to pay an ongoing royalty fee of 4% of your sales, as well as an ad royalty fee. Once we see all these McDonald's commercials all over the place, the franchisees are the people who are paying through this because they're paying 4% or more of their sales to McDonald's corporate to put together and to run these commercials all over the media. Okay, so it can take a significant amount of money to get it up and going. You can see another one, Sonic, sort of similar, $1.2 to $3.5 million initial investment. They require you to have a net worth of $1 to $2 million, but to be liquid between $500,000 and $1 million, pay an initial franchise fee of $45,000, and then ongoing royalty and ad royalty fees. So you got to think of your sales, your gross sales, you're going to have, possibly, somewhere between like 6 and 10% taken out, paid directly to the franchisor for all these fees. So, it can be pretty significant. Let's look for one that maybe doesn't require as much initial investment. So in Anytime Fitness, between $107,000 to $722,000. It's a pretty wide range. Of course, it's going to depend on location as to how much it's going to cost to open one of these things up. Their net worth requirement, $300,000, liquid cash, $100,000. So that's, much more realistic to a lot of people once you've been working for a while and able to save up some money. So, all franchises don't have to be extraordinarily expensive. Some of them are relatively affordable. But you have to understand there's going to be limitations on what you can do. You're not an independent business owner who can do anything they want to. You have to basically follow their business model. So it's a good way to potentially make money if you are selective about your location and the franchise and, everything else having to do with being a smart business person. So it's a very viable business opportunity for a lot of people out there. Switching back. So switching off of franchises for a little bit. So licensing is another type of business relationship. Licensing is very common, happens all over the place, and we may not even recognize it when we see it. But the basic idea is that somebody owns some type of intellectual property, and they're going to allow somebody else to use that for a fee. So they're going to charge money for somebody else to use their intellectual property. So some of the terminology, licensor is the person who grants the license to a licensee. An example, we see this all over the place, like I said. So Disney doesn't manufacture, they don't themselves manufacture all the things that are sold out there that has Disney images on it. Toys and clothing and, whatever else you have out there. What they'll do is they'll license those copyrights and trademarks to manufacturers who make and sell that, and they have to pay a licensing fee to Disney for the right to use those images. If you're using those images without permission and payment to Disney, then you could potentially be sued and cost you a lot of money. And Disney is very diligent about protecting their intellectual property. That's basically their entire business model, is the property that they own, the intellectual property that they own. So yeah, you gotta be careful. When you see people selling bootleg T-shirts outside of a football game or something like that, that probably, well, if it's cheap, it's probably unlicensed merchandise, or maybe it's stolen. Visual may or may not help the licensor, grants permission to the licensee for a fee. A joint venture, different. This is an arrangement where two or more business entities combine their resources to pursue a single project or transaction. They're oftentimes limited time frame projects to accomplish some specific goal, although they can last long term potentially. The joint venturers, these are the parties that are involved, however many of them there are, they do owe duties of loyalty and care to the other joint venturers. So we talked about those duties of loyalty and care back when we talked about partnerships and LLCs and stuff like that. So you have that duty to not try to undermine the business by pursuing my own interests, and I do have a duty to pursue the joint venture's interest once we form it. And then you can have variations on what a joint venture can look like. So you can have a joint venture partnership where you have, it basically looks like a partnership formed as a joint venture. And then you can have a joint venture corporation, which is where we go another step to actually incorporate the joint venture as its own entity. And the difference would be similar to what we see for general partnerships and corporations with regard to liability. For a joint venture partnership, we have the two joint venturers here. They invest capital into the joint venture partnership. And since it's a partnership, the joint venturers both can be held liable for the debts and obligations of the joint venture partnership. So if we were going to do this, it's often the case that these two joint ventures would form a corporation, and then the two corporations would join the partnership to try to limit that liability. There's all sorts of ways you can limit your own liability. But a joint venture corporation, you don't have to do that because the joint venture itself is a corporation. So there's going to be limited liability there. The joint venture corporation, of course, is going to be liable for its own debts and obligations, but the joint venturers aren't personally liable for the debts and obligations of the joint venture corporation. So it's not really too many new concepts thrown at you. It's just the basics of partnerships versus corporation in the context of a joint venture. And then finally, a strategic alliance is more of an informal arrangement between two or more companies whereby they agree to ally themselves. They're working together to accomplish a designated objective. Oftentimes this can be used when trying to expand internationally. Joint ventures can also be used when trying to expand internationally. There's all sorts of business strategies for expanding internationally. But a strategic alliance is another example of that. It allows a company to reduce risks, share costs, combine technologies, extend their markets out. When I'm looking for new markets to go into, it's often the case where I don't know anybody in that market. If I'm looking at a foreign country, I don't know anybody there. I'm not that familiar with the culture. I'm not that familiar with how to personalize or customize products to be successful in that specific market. So I might want to work with somebody that's already there who understands that market better and join forces with them to try to get things going in that country. Now, a strategic alliance doesn't have the same protections as mergers, joint ventures, or franchising because it's more of an informal relationship. So there's not the duty of loyalty, of care, and things like that involved. So I just have to be aware that today's strategic partner could potentially be tomorrow's competitor. At that's a very big deal when you're operating in countries that maybe don't recognize intellectual property rights as well as the United States does. So this is a huge area of risk and of concern for people operating in a country like China, where it'd be very common for some Chinese manufacturer to see what I'm manufacturing. They rip off my idea completely, start producing their own product that looks almost exactly alike with the same technology inside, and start selling it under a different brand name. And then it could potentially be pretty hard for me to actually sue them because it's a different country and they don't recognize the US protections as well. So while it does offer a great opportunity to expand my market and expand my sales, there are also the risks that come along with it. So that's it for this lesson. As always, if you have questions, feel free to reach out to me. Otherwise, hope you have a great day.